All right, guys. Good evening. Jackie Broman here. This is take 3. I started a live video on Facebook a second ago, and I started it with the camera, but apparently you can't change from camera to share your screen on a Facebook Live. So then I tried take 2, didn't work, so quickly deleted that one. So take 3, here we are. Good evening. This is our first Facebook Live event that we had pre-scheduled, that I'm offering people to come along and ask questions if they want to. I've obviously also prepared some slides. So I've got some talking points to go through with estate planning for anyone who doesn't catch this live but catches it a little bit later. So hopefully there's some interesting information in it for you. So my name's on the screen, Jackie Broman. I'm the principal lawyer at TBA Law, and I'm an accredited specialist in wills and estates. So of about, I don't know if there's 12,000 or 20,000 lawyers in Victoria, one of the two. Quite a big difference, I know, but there's only 80 of us approximately with the accredited specialisation, and I'm the only one in Northeast Victoria, the only one in Central Victoria, and I'm the only female in the Riverina region. There are a couple of men in Bendigo and Shepparton. So what is a lawyer? Sometimes a silly question, but I do sometimes think that people get things a little bit confused. So I am a solicitor, which is a lawyer. Barristers are also lawyers, but barristers appear primarily in advocacy in court proceedings and don't usually run community offices and see clients directly. So barristers are usually subcontractors to solicitors, and they are advocates. If solicitors want someone particularly to do the court appearances, they'll get a barrister expertise at the court process. But having said that, I'm also a human. So there are some pictures about some of the things that I'm actually interested in outside of work. So I do go fishing a lot, particularly in the tuna season. We go down to Port Fairy a lot. So that's me in the top corner with 2 big tuna. That's in our old boat. We've now got a catamaran, so much better for the Southern Ocean. I ride a motorbike, and I've done my superbike school training down at Phillip Island. I've done Tough Mudder twice, and I've done Spartan Race 3 times. I do love an obstacle course, and also my dog is my baby, and that's the dog there in the bottom corner. He loves his fishing too. Now, this is just a few areas of the law. I've said that I'm a specialist in wills and estates. There's a hell of a lot of law that I don't do, some of which are listed here. Our firm primarily focuses on property law, wills and estates, and family law are our main areas. So just like a lot of other industries, things are getting more and more regulated and more complex, and so we tend to specialise in particular areas more and more. So there are getting less solicitors that are generalists. Oh, hi Legita, welcome. The first live event on Facebook. So yeah, there's lots of types of law, and you do like to look for a specialist in your area rather than just going to a generalist. So feel assured that I am a specialist in the wills and estates area. So when I talk about wills and estates, it's succession law, one and the same thing essentially. So tonight we're going to be talking about personal succession. part of the sort of law that I do also covers business succession, so particularly family businesses and family farms, with structuring and looking at succession to the next generation while the parents are still alive so it goes smoothly. Succession law also covers probate and letters of administration, and then also the trust and estate administration after someone passes away. So, getting into some nitty-gritty information, here's some value for you. If you pass away and you do not have a will, and there's approximately 50% of adults in Australia do not have a will, then the law in the particular state that you live in will apply, and it's the law of intestacy. So you are intestate if you pass away without a will. In Victoria, these laws changed a couple of years ago, and in my view, they're a bit fairer than they used to be, and the law sets out the order in which the estate goes to if you don't have a will. So if you have a spouse and no children, your spouse will get all your assets. This is always funny, if you've had more than one spouse in 6 years, and that means you have separated from one spouse and you have a new spouse, your spouses will share in the estate, right? So if you have had a separation, this is why it's important for you to have a will, because if you die intestate, then your ex-spouse will end up sharing with your new spouse. If you've got children, no spouse but children, everything will just be divided between your children. If you have a spouse and children, your spouse will still get the lot. However, if you're in a blended family, your spouse gets roughly the first $450,000, and then the balance of the estate is divided 50-50 between your spouse and your biological children that are not shared with your spouse. All right, so that's a little bit complex, but I'm sure you'll understand. Then if someone passes away without a spouse or children, so particularly teenagers in their late teens or people in the early 20s, or even people who are elderly and never had children, the next order applies. So if people's parents are still alive, it's shared equally between parents. So this is quite interesting in terms of perhaps a child's parents have separated. They might have a relationship with one parent and not the other. They might not want their estate to be shared equally between their parents. If they don't have a will, too bad. So another reason why young people potentially should do wills. If parents have passed away, then it goes equally between brothers and sisters. If a brother or a sister has passed away, their share goes down the line to their children if they have any. And only at the end, if there is absolutely no one in that person's life, does it go to the government. So don't worry that if you don't have a will, it all goes to the government. Still plenty of reasons to make a will. Because before we move on to super, if you pass away intestate, you don't get to choose who administers your estate. So that could be a factor in itself to make a will. Superannuation. So another asset that is often a biggest asset for people these days. We've got to put money into super by legislation, so that is accumulating, and most people have a life insurance component on their superannuation. I say this again about 18-year-olds, people who've just started working and are able to do a will. As soon as they do a will, they should do one, primarily as well because of super. So as soon as they start working, they'll have an industry fund, they'll have life insurance of $200,000. Super funds don't tell you, but there are categories of people that you can nominate as your beneficiary to be valid, and there are other people, and if you nominate them, your nomination is not valid. If you have an invalid nomination, The super fund will call for applications in your family members. They'll then make their own decision. And that's a lot of money to be out of your hands going to who knows whom. The other thing about superannuation is that they put it in the small print, but to have a binding nomination, most funds require a new nomination every 3 years or else it expires. So it is something to watch. So the points on this slide. Who is a superannuation dependent? So a superannuation dependent is someone that you can do a binding nomination to. So they are a spouse, a child, or someone who's financially dependent. So those 3 categories are superannuation dependents, and that is it. Anyone outside those categories, it's not binding. Then we have the difference between a superannuation and a tax dependent and a tax dependent. So the main difference is who gets the super tax-free and who doesn't. So a spouse will get super tax-free. Children under 18, or if they're still studying full-time and they're under 25, will get superannuation tax-free. No one else will. So even though adult children or financially dependent people can have superannuation paid to them under a binding nomination, they'll pay tax on it, right? Won't be a full amount of tax, it'll be reduced tax, but there'll be a big chunk lost. So sometimes in estate planning, we've got to think about how to save that tax. And then, as I've said, binding nominations, you have to appoint a superannuation dependent in your binding nomination to be the nominee to receive your super for it to be binding. And you also have to have it current every 3 years. It becomes a non-binding or a lapsed nomination after the 3 years, or if you haven't appointed someone who is binding. So, fairly complex area, and a lot of people miss the superannuation component. A lot of solicitors miss touching on superannuation when preparing wills, but it's definitely something that we do, and we do the binding nomination for you as part of the process. So finally, getting on to some crucial roles that you need to consider before having an appointment for your estate planning. If you've got children, you need to think about who the guardians are going to be for your kids. Now, I often say it doesn't have to be family. You need to think about who has the same values as you and who is going to raise your children in the way you want them raised, and who is most likely to follow your instructions. So that is who the guardian should be. Don't worry about money. Money should not play into as a factor. There will be enough money in life insurance and your assets to pay for the education and upkeep of your children while they're minors. Your guardian won't be out of pocket. An executor is also important. The executor is the one who runs the show after you pass away, collects in the assets, pays the debts, and makes sure that the will is followed. So it's obviously got to be someone who is trustworthy and generally someone who you think is going to survive you as well. Now, if you have minor children, you need at least 2 executors, and I usually recommend that one of those is the guardian, and then you always have someone who's independent from the guardian, because you can see that it may be a conflict of interest for the guardians to be the only executors. And then it's also important to think about trustees. So quite often the executor will become the trustee. So if you're comfortable with who you've chosen as your executors, they'll end up managing funds for your kids until they reach the age where they can inherit, okay? It doesn't even have to be minor children. We could be talking about a vulnerable beneficiary here, so someone who is disabled or who even has problems with money. If you're setting up any kind of trust in your will, whether it's a minors trust, protective trust, testamentary trust, anything like that, you can have a different trustee appointed to your executors if that's what you want. Just something to think about before an appointment for wills. Which brings us on to trusts. So when people talk about testamentary trusts, they're usually talking about a testamentary discretionary trust, which is the bottom one there. But all of these trusts are in fact testamentary, because a testamentary trust means a trust that is set up in your will. A minor's trust is the most common. A minor's trust is set up automatically if there is a child under 18, because they cannot receive their funds until they are 18. And this is common as well with people extending that age from 18 out to 21, 25, 30 even. So it's a minor's trust that will continue past the age of 18 until they reach that particular age, and then the trust ends. Education trusts could be used. So you could set aside money for children in your will to be used primarily for education. And once those children have finished their education, the trust then gets wound up and the balance of the funds can be distributed. It's a way of making sure that each child has the same opportunities for education as others, but some might use more than others, and they don't have to use it out of their own inheritance. A protective trust is a trust used for a vulnerable beneficiary. So, as I was saying before, someone with a disability, a protective trust may be suitable, although there are other types of trusts for disabled people. A protective trust may also be needed for someone who's a spendthrift, alcoholic, gambler, anyone really who doesn't manage their own funds well. So a protective trust could include just paying income to them for life. And then finally, a testamentary discretionary trust. My dog's just come in and is making a huge racket. But anyway, he's happy. So a testamentary discretionary trust is a fantastic investment vehicle if you have enough to leave for your children. It is a trust that doesn't end, but rather your children end up controlling. So you are passing on to them, like I said, an investment vehicle, which has tax benefits and also asset protection. So it can form protections against future breakdowns of marriages, bankruptcy, business creditors, all that sort of thing. So it is something to consider. It adds a little bit of cost to the will, but there's no ongoing cost because these trusts aren't actually set up until you do pass away. They just sit dormant in the will until then. Now, when we do our estate planning, powers of attorney are fairly crucial as part of it. I don't like letting people get away with just doing wills if I can do powers of attorney as well, because a will obviously only starts once you pass. So some people incorrectly think that appointing an executor in a will or guardians for children is like appointing a power of attorney, but it's not. If you're in an accident and are in hospital, either in a coma or having to do rehab for, a couple of months, you need someone to keep things going. A power of attorney can do that, okay? There are general powers of attorney, but what I really am talking about are enduring powers of attorney, because generally an enduring power of attorney doesn't start until you lose capacity, and then that's why it's called enduring. It endures past you losing capacity. So it begins then and ends either if you regain capacity or you pass away. So there's two main types of enduring power of attorney. There's a medical one, which changed in March of this year, and it's now called an appointment of a medical treatment decision maker, but effectively the same thing. We don't worry too much about that terminology. And then the other one used to solely be a financial power of attorney, but it changed a couple of years ago and now includes, as well as financial and legal decisions, it also includes decisions about your lifestyle and personal decisions. They used to have an enduring guardianship, which is what was rolled into the old financial power of attorney. because a lot of people weren't doing the guardianship power. And then when it came time for people to have to make decisions about aged care, a financial power of attorney didn't have those powers. So people were having to run down to VCAT to get guardianship orders, which was adding a whole lot of extra work. Yes, Acro does make everything better, doesn't he? He's gone now, thankfully. I couldn't even concentrate. So that's powers of attorney. The last couple of points I wanted to make before I'll let you all go, and so I can eat my pasta here that's starting to go cold, are some funny little rules in estate planning. So the first there, the youngest is deemed to have died second. So that applies to spouses. So if it cannot be determined who died first, if a couple passes away together, the youngest of the two is deemed to have died second, and therefore their will is followed. So if you're the younger of the two in your couple, then you're in luck. Your will is the one that gets followed. That's why we tend to do mirror image wills for couples rather than doing a will which is completely different after the two people pass away. Next rule, the forfeiture rule. So some people, usually jokingly, say that now their kids will be focusing on their inheritance and they might try to knock them off a little early. But the forfeiture rule is a funny little rule that applies, which says that if you kill someone, you're automatically written out of their will by operation of the law. So this obviously applies for murder scenarios, but it also applies even if someone isn't convicted and it's just circumstantial. And it also applies to the biological line of that person. So if it's one of the children who kills a parent, then not only is the child written out, but the children of that child are also out. Interestingly, there was a case where a woman killed her husband after suffering domestic violence for a lot of years. She couldn't get the inheritance. The law still stuck to that even though she got off the criminal charges, but she was able to get the life insurance. The 30-day rule, interesting little rule, and it's mainly to prevent a double probate situation, again, in the matter of the situation where a couple's pass away close together. So someone has to survive you for 30 days to be able to take a benefit under your will. Gift overs to children. So a lot of wills will say if a child of mine passes away, then the portion that they would have taken gets passed down to their children. This is actually automatic in law. So if you miss it out of your will, it applies anyway. So if you don't want your grandchildren to inherit, you have to specifically say that. However, it only applies directly to your children. If you leave money to a friend or a brother or sister, it doesn't apply to them. So it doesn't go down the line to their children. How to split up residue. So you can split residue up by saying, I give my residue equally to my children. You could say, I give my residue as to shares, and you say, I break my residue into 5 equal parts, and then child 1 gets 2 of 5 parts, child 2 gets 1 of 5 parts, child 3 gets 1 of 5 parts, child 4 gets 1 of 5 parts. So you could do something like that, or you could do it as percentages. And then finally, the last couple of points, a specific or a general gift. So this is quite interesting. You'll understand what a specific gift is. It's quite straightforward. It's and common. So I give my mother's engagement ring to my firstborn daughter. That's specific because you are mentioning a specific thing that you own. You can make general gifts, which is, like I said, quite an interesting concept. And it's often done in terms of shares. So if you don't actually own something, but you want to give something to someone, you can force the estate to buy it and give it to them. So it's mainly used in a scenario where a grandparent wants to leave something to a grandchild, but instead of leaving a cash amount, they might say, you know, I'll leave 500 shares in a particular company to that child. Now, that person may not own those shares, but it compels the estate to buy them and pass them on to that beneficiary. So that's specific or general gifts. Another example actually I use on this one is, now I don't own a red Ferrari, but I know my sister would probably really like a red Ferrari. So rather than just giving her cash in my will, I could say, I leave a red Ferrari to my sister, and the estate would have to buy one for her. So interesting little thing. And then specific classes of beneficiaries. So this is something that's used all the time as well, and you may not just be conscious of it. So obviously a specific beneficiary is a named beneficiary. A class of beneficiaries is when we say my children. So whoever falls into the class of beneficiaries at the time you pass away. So a better scenario or example would be, I leave $2,000 to each of my grandchildren who are alive at the time of my death. So you may only have 2 grandchildren at the time of doing your will, but when you pass away, you might have 20 grandchildren. So all of them are included in that class. So that's how some of those rules work. And that's some information for you about wills and estate planning. So the message is take control, do your estate planning while you can, and don't leave it too late, because when it's too late, it's too late, as I often say, particularly with powers of attorney. People will be running off to VCAT to sort things out, and it just causes more grief when your family is already grieving. So have a great evening. There's been a few people watch in and come in and out, and Legita's left a couple of comments. Thank you very much. If you are watching this in the future rather than live, then you can inbox me via the TBA Law Facebook page for any general questions that you might have. I don't want to get too much into specifics because it's hard to give you exact answers without having, you know, at least half an hour to have a chat about it. But my numbers, the general numbers, also on the screen. So we've now got 5 offices, so as well as Nagambie, Wallen, Melbourne, we've also got Seymour and Romsey, but the 1300 number gets you through to all of them. So you know who I am, you know what I stand for, you know what I can do for you. So give me a call if you need. And so I'm going to sign off. I'm going to have my tea and my spaghetti tonight, and until next time, good evening.